Petrofac Ltd and another.
Morning, Mr. Allison.
My lords, thank you. Good morning. I've spoken to Mr. Thornton about timing. Just so the court knows, I'm going a little bit more slowly than I had hoped. I mean, I'm not saying for a moment we're not going to get to where we need.
We've had a lot of questions, so no.
No complaint clearly in that regard from me. I understand why the court's had lots of questions. Mr. Thornton said he would like 45 minutes in reply. Subject to the court thinking he needs longer, we'll make sure we preserve at least that long for him. With that in mind, though, and with getting through the key points in mind, can I say the order I'm going to do things in this morning and hopefully early this afternoon to see if it commends itself to the court? A lot of questions in the court yesterday were addressed at the new money. So first I'm going to deal with the authorities on the new money. Second, I'm going to deal with the facts on the new money. That will include why the judge was right on the evidence before him to reach the findings he made, and also involve answering the question posed by the court yesterday about splitting out the returns so they show separately the returns on your plan claims and then the returns on the new money. Third, I'm going to deal with the other points made under the appeal, including, for example, the horizontal fairness complaint. And fourthly, to the extent that we have time, I will deal with why we say that the views of the appellants as out of the money creditors at PL should in any event be given little weight in circumstances where it's the secured creditors who have the economic interest in the business and they are the ones who are making the principal sacrifice under the plans. In other words, they are the secured creditors who get common ground, being that in the insolvency of PL they would share in essentially all of the recoveries with a 600 million shortfall on their claims. The reason I take it last is we do say the new money evidence and findings is an answer to the complaint about the new money which is posed, so we don't need to go to the final stage. In addition, if we get to that final stage, we will be saying to the court that to the extent the court has any concerns about, I'll call it broadly Virgin Active, the Virgin Active plan and all the others that have followed, which essentially have allocated in rough terms a little bit more than the prescribed part share to out of the money creditors. That is emphatically not this case. The reason why it's emphatically not this case is it's the expert evidence before the court that the warrants that go to the out of the money creditors have considerable value, around about 50 million of value split between the different groups of unsecured creditors. So that's my route map, if that is satisfactory to the court.
Yep.
Then could I turn to the authorities on new money? Hopefully I can do these relatively quickly. We deal with them in our skeleton in brief terms. The reason I raise the point is the appellants very much presented their case both at first instance and in a number of worked examples in their skeleton on this appeal by reference to nominal value of claims. And by that I mean they simply take the headline number of the new money, the headline number of the secured debt, and the headline number of the unsecured claims. What they do, for example, is they disregard whether something is new money, which is not even available to the company if the plan is not sanctioned on the one hand, or whether it is an old money claim on the other. Number two, they disregard, by using nominal values, the different ranking as between pre-existing claims, on the one hand between the secured status of certain claims and the returns in the relevant alternative on the one hand, and the unsecured status of their claims and indeed other claims in the relevant alternative, and within PL the anticipation there would be nothing for them save for a share of the described part. So the background is the nominal case theory was made at first instance, advanced in the written and closing submissions, and is made, as the court will have seen, in the worked examples that have also found their way into their skeleton arguments on appeal. Now the judge rejected that approach. We say he was right to do so. We say he was right to do so both because it failed to take account of the very different nature of new money versus already lent money on the one hand, and two, because he was right to take account of the very difference between secured rights and unsecured on the other. Now, my final point, secured versus unsecured, will come at the end of the piece. But what I want to deal with now is the difference of new money and what the cases have said on new money, number one, and then what the evidence says on new money, number two. Can we start, and I'll try and take the cases in chronological order. There are 4 cases to look at. They are Virgin Active, House, and then both Adler and Thames Water in the course of appeal. So can I start with Virgin Active, please, which is tab 13 of the authorities bundle. And to be clear, this is the sanction judgment. The convening judgment is in the bundle at tab 12. And I think I can do the facts, hopefully, for this point in brief terms. If we could go to page 350 of the bundle, paragraph 58. As the court knows, I'm at risk of repeating what I said yesterday. The purpose of this plan was to avoid a collapse into an administration which would have said trade for only 6 weeks and then all the stores would shut. So that was the alternative, a very short trading period and then a distribution within an administration. There were 2 principal groups of creditors before the court. The first is the group of secured creditors dealt with at paragraph 58 of the judgment. And in essence, just so the court can see what happened to them, the key thing that happened to them is that the term of their facilities was extended under the plan. So there was no compromise by way of equitisation or otherwise of any of their existing debt. It was an extension of their existing debt. The other main group of creditors were the landlords in respect to the premises operated by the group. And they, in the normal way as landlords, had only unsecured claims. And the evidence before the court showed that they would receive no return in the relevant alternative. And just quickly to make that good, can we go to page 362, please? And can we look at paragraph 100? And can I maybe pick it up 5 lines down the paragraph? Does the court see the sentence beginning with total estimated sales proceeds? So this is where my Lord Justice Snowden addresses the evidence in relation to the proceeds and sets out that the total estimated realisation was 223.6 million and that number was 39 million less than the amount needed to clear the secured debt and the other priority claims, leading to Deloitte's view that the unsecured creditors would be out of the money on a distribution within an administration, save for their share of the prescribed part. For the moment, I'm focusing on the new money aspect of the plan. And for that, can we go to page 402, please, of the judgment? Paragraph 278. And the reason I go, as we'll see in a minute, one of the key complaints by Mr. Dicker Queen's counsel on behalf of the landlords was that they were not given an opportunity to subscribe for any of the new money. Instead, the new money was all put in by the shareholders who were subordinated to them in the corporate structure. And so does the court see that at paragraph 278, it said, third, it is undoubtedly the case that the shareholders have agreed to provide significant contributions by way of new money to finance the future operations of the group. In essence, the point made is that the shareholders are paying an appropriate amount of new money for their retention of the equity, so they acquired their new money claims under their loans and retained their equity. The plan companies also contend that the debts to be compromised by the Class B to E landlords and the general property creditors under the plans are not comparable to that new money. One then gets a summary at 279 of the particular elements of new money that were provided. What I was going, though, to show the court next is the argument that was advanced by Mr. Mackenzie in his evidence. This is paragraph 280. Mr. Mackenzie was the expert witness for the landlords. So, advanced by Mr. Mackenzie in his expert evidence and by the HG landlords in their written submissions was that the 60.4 million new monies to be provided by the shareholders should be equated with the required write-offs of rent arrears and future rental arrears under the plans by the Class B to E landlords, which they quantified at about 41 million. Mr. Mackenzie and the AHG landlords submitted that this should result in the shareholders and the Class B landlords sharing the equity of the plan companies after the restructuring in the ratio roughly 60 to 40, which reflects the ratio between the new money on the one hand and the unsecured claims on the other. So that was the submission to the court. Then paragraph 281, attention is drawn by my Lord Justice Snowden to the fact that actually the waiver of 9.4 million by the shareholder is probably different because that's not truly new money. So that is then pushed to one side. And then at paragraph 282, there's consideration of the remaining elements of the 60.4 million new money. And what is said is, however, that is not so for the remainder of the payments to be made by the shareholders. There is, in my judgment, a considerable difference between waiver of liabilities already contracted for, and which would be worthless in a formal insolvency, and new monies which will, if the plans are sanctioned, be made available to finance future operations and which will be at risk from those continuing operations. So,
And just to put that into context, this was a plan in the middle of the pandemic of a chain of gyms. There was absolutely no assurance in the middle of the pandemic that that this plan would actually work, in the sense that nobody knew whether the continuing operations would go on for any length of time. So there was substantial risk.
Clearly, we don't dissent to that, and I think, getting ahead of myself, I'll try and stick with the law. But if I may just address that very quickly, we say the judge was right to find that there is considerable risk in relation to the new money in this case. We'll explain why in due course, particularly in view of the observation that my Lord Justice Snowden just made. But I think just headline points at the moment, this is not a group with hard assets. There's no property, there's no intellectual property, there's nothing which readily realises for the benefit of the creditors. As explained very clearly in the evidence, the expert evidence, and the risk factors in the explanatory statement, this is a contracts business. It all depends upon the future profitability of those contracts in relation to which there is risk, Toil being an example of such risk, one wrong in relation to that contract. And by taking equity in the topco, PL, when all the contractual relationships are lower down within the group, you are subordinating yourself to all of the claims under those contractual relationships. So yes, if the business plan is realised in accordance with its terms, the realisations will be as shown in the expert evidence. But we do emphasise, and I'll come back to the individual points a little later, it would be wrong in our respectful submission to see this anything other and involving considerable risk, and the judge was right in that regard. And I mean, I won't steal Mr. Bayfield's thunder. He will deal with that point from the perspective of the ad hoc group as well. So that's paragraph 281. 283, the judgment looks at what was said by Mr. Nicholson in cross-examination. Now, similarly, in the current case, we benefited from cross-examination of the witnesses. Mr. Susan, the group CFO, was in the witness box. Mr. Reid, on behalf of the AHG, was in the witness box. And Mr. Bennett of Teneo, who prepared the comparator report, was in the witness box, and they were all cross-examined by Mr. Thornton. And we will say that nothing within that cross-examination touched on the very clear evidence as to the need and pricing and risk of the new money. In this case, Virgin Active, Mr. Nicholson was giving evidence. Mr. Nicholson is of Deloitte, and he was giving evidence on behalf of the plan companies as to the attempts to secure new money and why they would find it hard to find new money elsewhere. So 283 is setting out that evidence. And then can we look at 284 together, please? Where the court says, moreover, even which I do not accept the write-off under the plans of the claims of the landlords could be characterised as contributing to the restructuring surplus, those write-offs would not stand alone under the plans of the other unsecured creditors also to be compromised and would qualify for similar treatment. Now, that chimes to the point we made before the judge, and the judge picked up in the judgment when saying, one, the relevant alternative was not Mr. Thornton's, and two, why it shouldn't be relevant in terms of discretion. We can't just give them a good deal without giving anyone else a good deal.
Is that first sentence right? Why isn't it the case that somebody who agreed or is compulsorily written off, their debt is compulsorily written off, why aren't they contributing to the benefits of the restructuring if by writing their debt having been written off, the value of what's left, the company, is substantially enhanced? I mean, is that right, that first sentence of 284?
Well, one, that's our fourth area of submissions, getting into that, the out of the money.
But as a general proposition here, restructuring plans, if you have, you take the relevant alternative and you say, what would everybody get if nothing else happens and this company is liquidated and the assets are sold and people get a distribution? That's when people say that the secured creditors in that sort of circumstances are the economic owners of the business, they're wrong. Because in fact, what they are just people who would get a distribution of the sale of the assets in a liquidation. But what the restructuring plan does is to preserve in being a corporate entity which has a value going forward. And I think we said later in Adler that rather than using the concept of restructuring surplus, I mean, what you are looking at is the difference between what people would get from a liquidation of the assets of the company with no business going forward, as against the survival of a corporate entity with a viable business, including goodwill and the ability to exploit its business and assets. And those two things aren't the same. So that why isn't it right to, why is it right? Why was I right? Or more to the point, was I wrong to say that if you have your debt written off under a plan, you don't really contribute to the benefits of the restructuring? You do, don't you? I mean, it's an involuntary contribution, but you're basically your debt is being eliminated for the benefit of the people who are sailing off into the sunset with the corporate ship.
Can I give my lord a short answer now and a longer one maybe when we come back
Yeah.
the out of the money point if we hopefully have the time later on. Yes, in the sense that everyone who writes off their debts can be seen as contributing to the ability of the business to continue as a going concern. The but is this. The but is you need to look in our submission at the relevant alternative to the plan to understand what those rights would really be worth in the relevant alternative. And in that regard, we completely agree that to the extent that this is a general catches all plans statement, we wouldn't agree. And we think in that regard, the approach of
I think it's the first time I've actually got anybody to agree that I was wrong in Virgin Active on anything apart from my lord in Thames Water. But
we would then very respectfully suggest that the Court of Appeal in Thames was right to focus on what the relevant alternative is before working out what people are contributing in terms of their contributions to the benefits of the restructuring. And what we do say, we say it's Thames carefully in our submission distinguishes between three possible scenarios, and it doesn't say these are exhaustive, but it does distinguish between three. One, an interim plan such as Thames, which is a bridge to get somewhere but not a full balance sheet restructuring. Two, a distribution of assets within a wind down under a plan instead of a formal insolvency, that's Adler. And three, when you need to preserve the going concern. And I think what we say we get from Thames, and I don't, if it's satisfactory, I don't want to be blown too off course now in view of the new money point I want to deal with. We say that Thames is right in saying just how important the out of the money point is depends on all the circumstances, including in particular what your relevant alternative is.
okay.
Can I just ask, where we are now is on the new money bit. Is the proposition you want to get out of Virgin Active only that you can't equate provision of new money with write-off of existing debt?
My lord, yes, that was
Yes, that's a fairly obvious proposition.
In which case, I don't think you need to. But it's useful to highlight that as a standalone proposition, the first sentence of paragraph 284 doesn't appear to be correct. If taken out of context,
if taken out of context, that would be my submission.
well, even in context, if applied generally, it's probably not correctly stated, is it? Just to be clear. I mean, in other words, people whose debt is written off under a plan should be characterised as contributing to the benefit which the restructuring plan gives. And the question is, how much should they get?
Again, without
for that contribution?
Without wishing to be blown too off course in relation to the new money, the answer to that in our respectful submission is the court is driven by what the relevant alternative is, the value of the rights in that relevant alternative, paying regard to priorities within the capital structure. Because if you don't,
but they're not. But they can't be the sole driver, because if you get nothing in the relevant alternative, that doesn't mean that you should get nothing for your contribution to the new shiny ship which sails off into the sunset shed of your debt.
And my lord, maybe just in response to that, that may be a very interesting point to debate in a case in the future in which there is no new money. The senior secured lenders simply extend their debt and the unsecured is written off in its entirety as being out of the money for nothing in return, save for an enhanced share of the prescribed part. But we do say on the facts of this case and the other new money cases, the new money makes all the difference, because once one accepts as the judge, we say rightly accepted, that the group needs the new money, the group has fought hard to get the new money, it's got it in at the best price it can, reflective of the risk. It is only then the rump of the benefits of the restructuring that can be shared.
Okay, well, we're going to come back to the facts, but okay. Anyway, sorry, do we need anything more from Virgin Active?
My lord, the submission by Mr. Dicker is in relation to new money. So number one, my lord, found that in relation to new money, as my Lord Justice Zacaroli just summarised, new money different to old money. We agree. Number two, page 404, paragraph 285. The primary objection in relation to the provision of 6 million to be injected by way of equity to finance payments of the relevant alternative return, and the provision of the 45 million of new liquidity to finance the operations of the group. So the primary objection in relation to the subset that my lord found was truly new money. After the plans take effect, was that the AHG landlords had not been given the opportunity to participate in their provision, and that the new junior facility was not provided on market terms and negotiated at arm's length. So, two complaints made there. One, they weren't allowed to participate, and two, not on market terms and at arm's length because it was coming from the shareholder. Can I show the court where both of those points were dealt with? The not available to all point was discussed at 286 through to 290. Can I please show the court the conclusion on page 405 in the last, in 290, I'm so sorry. So, putting that aside, the other common feature of each of these cases is concerned that the creditors, given the opportunity to risk participate in the scheme cases, might be receiving something that we described as an incentive to skew the vote, or that the existing equity holders who have subscribed for the new equity, that's a reference to a case determined in the US courts, were not paying full value, top dollar, for their new equity. And then the conclusion, in either situation, the underlying concern is not so much to impose a procedural requirement to offer an opportunity to all. The concern is that the terms of the risk participation or equity investment are the best available. Are not the best available, I'm so sorry, not there. Are not the best available, but include an element of disproportionate financial advantage or bounty for the relevant creditors, which is not enjoyed by other similar or senior ranking creditors. So, answering the first part of the two challenges within Mr. Dicker QC's argument, it doesn't need to be made available to everyone. That's not the key concern. The key concern is around pricing. And then could I show the 293, where there is the conclusion, the summary of Mr. Nicholson's evidence in relation to availability and pricing. So he said,
well, he actually only deals with pricing, actually, I think, in reality.
I think he says two things. He says it was essential for the new money to be obtained and highly unlikely that it could have been obtained in the market.
Right, okay, but he doesn't deal with the, so just the not available to all. I mean, again, let's just test this. Is it right to say that when you are determining or the allocation of equity in the new restructured company, that you can exclude from that benefit creditors whose debts are being written off and who to that extent are contributing to the creation of equity value?
Can I maybe give my Lord Marks, which is not, I hope, not unhelpful before dealing with that express point? On the facts, it may be a relevant question one day. On the facts of this case, the evidence showed.
Okay, but can we just, sorry, I do want to try and keep this to your framework, just as a matter of concept, because I appear in that paragraph to have answered it as a matter of concept, to say that Mr. Dicker's concern about that equity was not available to everybody who had been contributing. First of all, I said not everybody's contributing. I think we've established that's probably not right as a general proposition.
For all plans, yes.
And so, I mean, almost by definition, the next answer is also probably wrong. But is it the case that you can differentially allocate equity in the new co, missing out and not giving that advantage to a group of people whose compromise of debt is essential to create that value?
We say yes, it is. And we say, I imagine the argument would go in a case which raised it in clear terms. We don't have anyone in this case saying we wanted a chance and weren't given it. But if someone in a case were to say that, in our submission, the answer would be, well, the court has to be satisfied the pricing is fair as part of the overall exercise of its discretion in any event. And having got there, the distribution of the benefits are appropriate because they take account of the pricing of the new money. In other words, if someone found it unfair or inappropriate, it would be for them to show that they would lend on better terms such that the new money was not appropriately priced under the plan.
All right. But then we do come down on any view as an alternative to the point that if the new money is a means of conferring what I call disproportionate financial advantage or bounty, then that would be a reason to refuse to sanction a plan.
My Lord, we don't dissent from that. If the court were to find that the evidence shows, to use, I think the language intends, excessive, the rate's excessive, or other adjectives to similar effect, yes.
What justification is there for having anything other than market terms for the provision of new money post-restructuring? Why shouldn't the company just be able to go into the market post-restructuring and get money on the best terms?
I see my Lord's question. Because fundamentally then you don't have a restructuring. There is no restructuring without new money. The show cannot be kept on the road and the creditors will not agree, understandably, to the compromise of their debts without.
But it cannot, the whole point I think I was making there, which I would think is correct, is that a particular group of creditor can't hold, in a sense, everybody to ransom and say, well, because we won't agree to restructure our debt without taking, without also having the ability to lend new money at disproportionately advantageous terms, we must be allowed to do that.
And we're not suggesting
otherwise,
to be clear.
Right, so it is an objection to a plan that if there's an element of disproportionate financial advantage or bounty, and I'm just using those words, there's no magic in those words, but everybody knows what we're talking about, that the new money is not available or is being provided on non-market terms, that could, in an appropriate case, that could lead a court to refuse to sanction a plan.
On the facts of an appropriate case, we accept that could lead to the court refusing to exercise its discretion to sanction a plan. Absolutely, but and again, at the risk of getting ahead on the facts.
And so testing the market for new money, I think it's the point that I was then making, that testing the market for new money and the rate at which new money to a restructured vehicle could be provided or could be obtained in the market is key, which is what I think the American cases show. I mean, in the American cases, they do look very carefully at whether the restructured company is paying more than a fair rate for new money.
I think I put it maybe slightly differently. What is key is that the court is satisfied that the evidence shows the new money need. The evidence shows the length to which the company has gone to obtain the new money.
Yeah. And
the evidence shows that the company's position is established, that it's the best terms they can achieve for the new money they need. And we say that all of those facts are borne out by the evidence clearly in this case, as found by the judge. I would not for a moment suggesting that if one came to the court with a plan that offered a disproportionate return on new money, that would be enough, simply because the group needed new money. I think where I'm maybe slightly parting company with my lord is not really knowing what my lord means by market testing, because as Mr. Sousa explains, there was extensive outreach. They couldn't have done more in this case to find new money.
We are going to come on to the evidence to, I think, to look at carefully what was done. But just as a proposition, my understanding and my recollection, which is reflected in what was said in this passage, I think, is that certainly from the US cases, which I was taken to as a sort of help in the early days of this, that there is a concern in the US that people shouldn't use their existing position within the company to force the company to take new money at non-market terms. Putting it in a different way.
And again, I don't think we're disagreeing with anything my lord says in relation to another case.
No, I'm trying to deal with your authorities just as a general proposition, just to sort of get straight in my own head what proposition I think you're trying to take from this case, this Virgin Active case.
Then I think three things. Number one, new money's different.
Yeah.
Number two, new money still needs to be appropriately priced rather than giving some disproportionate return or bounty to the person who's providing it. And number three, it doesn't need to be made available to everyone. We say that those 3 points are right from the case.
If it's priced appropriate.
Oh, well, of course, yes.
Because then it's just a cost, isn't it? It's not really a benefit at all, it's a cost of the restructuring.
Absolutely, you're looking at precisely. The next case is just I'm reminded what the evidence was before the court in Virgin Active as summarised on the test. It is 297. Mr. Nichols's evidence was not seriously challenged, and I had no other evidence as to the terms upon which the 45 million of new money might have been obtained in the market from any other source, still less that it might be obtained on better terms. I therefore accept his evidence.
That I do recall.
Now, that we do say is the key test and is reflected, as we'll come on to a moment, in Thames. And when we get into facts, it's not good enough for someone just to come along and say, your pricing's wrong, by way of mere assertion. There's got to be some evidence as to what's gone wrong.
I mean, that will depend upon, that will always depend upon the facts and, you know, where the evidential burden lies at any particular point. I mean, as you know,
to be clear, I'm not suggesting that if a company adduces no evidence about the efforts taken to obtain the new money and the new money needed, that would be sufficient, and someone would still need to bring evidence to challenge it.
Or if the evidence that is brought forward actually raises more questions than it answers, then the court would still potentially be able to say, well, that isn't good enough.
Well, the court would, but I think in that regard, the one, and yes, of course, for a trial judge hearing the case, but I think the point we would make in that regard, one, our evidence we say is
Well,
clearly good enough, but two, more fundamentally, there was no challenge to the evidence on pricing, no challenge to it being made available elsewhere during cross-examination, and no expert evidence filed to suggest there was in fact better pricing within the market. So that was the world that the judge was operating in. And that was why he made the clear findings he did. There was no challenge to the company's evidence on that.
we'll come on to it.
Can we then move to Housed, which is tab 16, a decision of my Lord Justice Zacaroli. It's an unopposed case, although it does have a detailed consideration of the issues because it involved a non-pari passu distribution as between HMRC and the bank. HMRC would have done better than the bank in the relevant alternative.
What's the proposition you're going to get from the remaining three cases? Is it anything more than we got from Virgin Active in terms of proposition of law?
My Lord, I think not, and that's incredibly helpful to move me along. And my Lord will clearly have this in mind. The one point that we do make in relation to Thames, and maybe we can just show the court that before we move on. It's tab 24 of the authorities bundle, page 816. One of the grounds of the appeal was an allegation that the new money was overpriced, and that was not taken into consideration by the judge and gave rise to a reason to set aside his decision. For the court's note, it's paragraph 89.4 that sets out that ground of appeal. That's page 797. The passage that I wanted to show the court is where that ground of appeal is dealt with at page 816. Paragraph 208. The court first deals with comments by the judge in relation to the B plan, i.e. the other plan suggested by the junior lenders. The B plan is not pursued, and it was not suggested that the relevant alternative was bridge financing from another source in the market outside of SAR. As the judge noted at paragraph 253, super senior funding from another source could not have been obtained without the consent of all secured lenders. So the court does rely on the fact that you need consent from all other lenders to get the super senior money.
But that's in the context of a bridge plan.
But putting new money in within a bridge plan, though.
Yeah, but it's not. But it's not putting new money into a restructured company.
Well, we would respectfully suggest that the last part applies equally and chimes with the test we saw in Virgin Active at 297, which is there was in any event, as Mr. Thornton fairly accepted, no evidence as to what terms are available in the market, without which the assertion that the costs associated with the SSF
that's a
are
different.
excessive.
Sorry, that's a different point. There are 2 points. So I was picking you up on the first point.
I'm so sorry. The one that I wanted to go to is chiming with the same approach as Virgin Active in relation to how does the court, clearly being non-expert in what the market is.
Okay, that's all. Yeah. Okay.
The court, in our respectful submission, for obvious reasons, can't sit there and reach an assessment of its own on what the market is.
Fine. If the only point you're getting from this is the last sentence, then I'll shut up.
Sorry, my point is mere assertion is not enough. You need evidence. So, my lords, they are the cases on new money. And we do say that the court will look first if the company does require an injection of new money to trade, then it may be appropriate for the new money providers to get an enhanced share of the benefits of the restructuring. And two, the courts, if there is an attack, will look at whether the money is excessive, to use the language of Thames, or whether it involves bounty, to use the words in Virgin Active, and will do so by reference to, in particular,
or disproportionate benefit.
my lord, yes, we will do so though in particular by reference to any evidence as to other market rates as to new lending available to the group. It's got to be available to the group. Shall I then turn to the facts on the new money? Does the court have the agreed note on the breakdown of the new money that we handed up yesterday? It's at paragraph 9, page 4. So as correctly understood by the judge, the new money divides into two categories. First, 218 million of new money is advanced by the senior secured funded creditors. 30 million of that is cash collateral provided by one ad hoc group member at the bottom. There's no equity return attached to that. The money that, the new money that does give rise to new debt claims and equity return is the split between the new money notes and the new money equity. Now that, does the court see the two 93.75 million figures either side of the dividing line? So 93.75 million of new money equity for the participating senior secured funded creditors and 93.75 million of new money notes for those creditors. Now, at the risk of repeating what I said yesterday, but maybe worth just going back quickly, those participations are open to the whole of the secured creditors on a pro rata basis. And as we explain in the note, and I would hope the maths in this regard are agreed, what it means is that for every $100 of existing claim the secured lender has, they can provide $20 of new money split between equity and notes. That's no more than dividing 187.5 million by 940 million, the total secured claims that can participate. So for every $100 of existing claim, you get a right to provide $20 of new money. Paragraph 15 of the appellant skeleton asserted that the ad hoc group has a right to participate in 44 million of new money for every 100 million of existing debt. Now that's just plain wrong, and that can be seen on the figures. The right to participate is $20 for every $100 of claim.
Was there a second, third, fourth round of this? So if the full subscription isn't taken up, then those with the original...
No, of course, I'll come to the note, in fact, that does that, because there was a backstop arrangement. It was made available to all, but in the normal way, we need to make sure we would raise the money. The backstop arrangement was made available generally to the whole class. Only some took it up. As a result of the backstop, the end position is that the ad hoc group will be able to do $29 for every $100 of claims.
It was theoretically possible for the whole of the new money to be raised within the ad hoc, within the senior secured creditor group, theoretically.
In relation to the 187.5 million, yes.
Yes, you didn't. The fact is, I think one of the points you make is the fact is not all of the senior secured creditors took up the offer, which is why you had to go elsewhere.
No, I'm sorry, we were at cross purposes. Yes, the most that we could secure from the senior secured lenders was 187.5 million by way of the notes and equity. That was made available to them all pro rata. We couldn't fill any more from them, so the rest is obtained elsewhere. And really just running that through, the court can see in broad terms, the senior secured class, the planned creditors, provides less than 50% of the new money required in this case. And this isn't a case where the ad hoc group is the secured class, as many cases are. They have only 35% of the secured debt. So that's the first part available to the existing lenders. Then, as the judge correctly observed and split it out, the balance of 226 million is provided by others who are not plan creditors, save for Nuttree for a small amount, which I'll deal with next. And that's because Nuttree is the single most important entity in respect of new money provision. And I say that because it has agreed to do two things. First, it has agreed to provide $75 million of new money, as the court sees on the table, split equally between equity and new notes. And second, it is providing $50 million of cash collateral to the group under the CBG notes, which are, as explained by Mr. Sousa, crucial to cash collateralised ongoing contracts. Now, importantly, there is no equity return attached to that. So,
how risky is that? How risky is the CBG notes?
It depends on the performance of the underlying contract.
It sits there as collateral at the moment, but as soon as you start entering into contracts, that's called upon to pay cross guarantees or performance guarantees.
Precisely. So at risk is the clear answer to that, unless and until one can find alternative performance guarantees to deal with the problem.
And what's the return on that?
I will try and get the reference to the X-plan and the convening judgment to give my lord a precise answer to that. It's not particularly material, I think, is the answer.
It's not free.
My lord, of course, it's not free.
No, that's fine.
I wasn't suggesting for a moment it was, but the fundamental point, I can show my lord, maybe paragraph 11 of the note, that's where I wanted to go. So it's detailed by the judge in the convening judgment, but then we summarise it at paragraph 11.
So, wait a minute. So, when is this right? The CBG facility, you make available 80 million in cash in exchange for notes from that vehicle. In addition to the notes by the vehicle, participants receive 19.57 million of notes from PL on the same terms as the new money notes. So in other words, that's 9.7. Is that 9.75% or something?
Yes, I think it is.
Yeah. And is this right? A cash payment and a contingent value right instrument worth 9.8 million.
My lord, yes, that's the return.
So Nuttree puts in 50 million and gets 19.57. So it gets the notes by the special purpose vehicle. Do they carry interest? It gets 19.75 million of notes from PL, which carry interest at 9.75% and cash, and a contingent right instrument.
My lord, it does. But
I'm just sorry. I'm just. Yeah,
no, I'm sorry. I wasn't.
It's not a course of complaint. I'm just trying to understand what that paragraph actually means.
And it's dealt with in detail in the reference we've given in the convening judgment and within the explanatory statement, which are the tab 41 references. The short point on that is, as explained carefully by Mr. Souza, there are no performance guarantees for these contracts at the moment. Without the CBG facility enabling us to cash collateralise them, the ongoing contracts do not work to produce the return the group would otherwise receive from them. And of course, the cash collateral is fully at risk in the event that an underlying customer requires payment of it. Can I maybe show the court my lord, I've misspoken. The 19.57 million, just to check that we are in the same place, is made available to all of the note holders. In other words, that's pro rata as between the whole 80 million of notes rather than just for Nuttree.
No,
I think
that's what I understood. That's what I
There was
understood.
concern it wasn't. The judge found that without the support of Nuttree, there would be no restructuring, and accepted the clear evidence of Mr. Souza and Mr. Reed that Nuttree would not agree to any changes to the terms on which it was putting in the new money. Now, the judge reached those findings after hearing cross-examination of Mr. Souza and Mr. Reed. Can I, the court state that paragraph 56 of the judgment, and also the findings were based on Nuttree's letter to the court. Can I maybe show the court that? That's supplemental bundle tab 36.
Sorry, where do you want to? Yeah.
I'd like to go to page 1169 of the supplemental bundle. So, sorry, if we could just go up to 1167 on the screen. So this is a letter written by Nuttree, the key financial investor, explaining its position. Can we then go to page 1169, please? And it's paragraph 15 in particular. maybe with the Court's permission, I could stop at paragraph 13 where they say further, we will not entertain any modification of the term sheet nor equity capitalisation table, and for the avoidance of doubt, nor would we ever have entertained any settlement proposal that resulted in changes to the equity capitalisation table. We wish to make clear that in supporting the plans in their current form, we are not seeking to obtain any unfair recovery or undermine the successful restructuring of the company. Our position is in fact the opposite. And then they explain what's happened since they committed.
I mean, this is in the context of Plan B, isn't it? The judge deals with this, and the letter is written in the context of Plan B being put forward by Saipem and Samsung. Just so I'm getting my location of why this letter is being written and what the judge is referring to it at paragraph 56. I mean, this is all is part and parcel of the what's the relevant alternative? Is it Plan B?
My lord, yes.
Yeah.
The point, though.
No, I just want to locate where what this letter is aimed at.
Well, the letter's actually aimed. It's dealt with in the context of the relevant alternative within the judgment. The letter is aimed at both the Plan B and its general attitude to the restructuring and not countenancing any further changes, and the fact that it would walk away otherwise. In other words, that these are the best terms it will agree to. So, paragraph 14, they say, we wish to make clear that in supporting that, sorry, I'd read that bit, our position is in fact the opposite. Since our initial commitment letter was agreed in December 2024, the markets have moved substantially with companies facing plummeting stock prices. With a lot of the terms of our commitment letter, despite the deal economics already being far less attractive than when we entered into our original commitment letter, particularly as compared to alternative capital investments available today. We will not, however, accept any amendment of the terms of our commitment which worsens our position. So we do say fundamentally important when it's common ground, the deal doesn't work without Nuttree because we can't then fill our new money need. Paragraph 15, they explain that they are now a creditor within the senior secured debt, but that they obtained that after the date on which they committed to provide the new money. So they now have $23.4 million of claims, and then they're addressing head-on in Roman 1 and Roman 2 what would happen if the plan failed, and the suggestion that they wouldn't choose an insolvency because they hold a claim of 23.4 million. And they say, we wish to make clear that this is not the case as our investment was de minimis, less than 0.1% of the assets of the relevant funds, and we acquired the debt for less than the anticipated relevant alternative returns, and so the risk of liquidation to us is low. So, clear statement from Nuttree in relation to its position, relied on by the judge, backed up in terms by Mr. Sousa and Mr. Reed in both their written evidence and during their cross-examination.
Was there a witness called from Nuttree?
My lord, there was not. But there was this letter and Mr. Reed of the ad hoc group in particular, who had dealings with Nuttree, was asked questions about whether he really believed that Nuttree would pull out. He said yes, and the judge accepted that evidence. Mr. Sousa was asked similar questions. He said yes, and the judge accepted that evidence. And just finally, paragraph 17, Nuttree made clear that if the plans aren't sanctioned, they would not be providing bridge financing to allow a further opportunity to try and reach an alternative deal. I note the time, but the one point that I was going to try and do before the break, in fact with Mr. Perkins' assistance, if the court permits, is answer the question posed by the court yesterday in relation to breaking out the recoveries with the table that was sent to the court. Or that can be done after the
No, let's do it. Let's do it.
Thank you, my lords. It falls to me to deal with a discrete point relating to the figures that Mr. Anderson alluded to. Now, these figures arise in a table that can be found at paragraph 23 of the agreed note from yesterday. And there are some questions that my Lord Justice Zacaroli asked some questions about. I think it's worth pulling up in the first instance that table from which the questions derive. Now, this table shows the plan outcomes, in other words, the returns. It shows the returns to the various classes of planned creditors. And the line item that we were particularly focused on yesterday was the first one. So in other words, the returns to the participating secured creditors. We're focused on the plan outcomes column. And for ease of reference, I'm just going to use the likely low case figures that will avoid confusion. Now, the figure that can be seen right on the left-hand side, likely low case plan outcomes for the participating secured creditors, is 695 million odd. In fact, it rounds to 696, but I'm just going to use the first three numbers. Now, in relation to that figure, my Lord Justice Zacaroli asked, I think, two key questions. The first question was, what exactly is the figure at 595 million? My Lord identified that it's a blended figure, but the question is, how exactly does it fall to be broken down? And the second point was, how does one bridge from the recoveries that one sees in this table to the total value available for allocation pursuant to the restructuring by way of enterprise value or otherwise? Just to deal with those questions in turn, what is the $695 million figure a blend of? It's a blend of three things, just to be absolutely clear. Firstly, and I'll show you your lordships this very shortly. Firstly, it's a blend of the value of the shares allocated in respect of the existing secured debt. And that allocation flows to all secured lenders. There is then a figure representing the value of the new money, and that, as we shall see in a moment, is presented on a net basis. Just dwelling on that point conceptually, the reason why that's appropriate is that obviously funds have to be put up in order to earn the returns that derive from the new money.
So when you say net gross, do you mean it's net of what or gross including what?
So it's net of the sums injected by way of new money. Put it like this. Suppose that a new money provider provides $100 and receives back $120. It is potentially very misleading to say that a return of 120% has been earned in respect of that new money. The return is 20% on top of the sum provided. And so when I refer to the net returns on the new money, what I'm referring to is the returns less the sums advanced by way of principal, in the case of a loan, or the equity injected. We'll see the figures in a moment. I just wanted to be clear that that's the basis of presentation here. And then third and finally, the third element that constitutes the 695 figure is the fees. That the fees are actually built into that figure. It's not immediately obvious, although it will become clear very shortly. That is to say, the backstop fees and the work fee are blended into that figure. So it is very much a blend, to use the term that Lord Justice Zacaroli used, I think, firstly on day one. So the next question is, how much value is attributable to each of those three buckets if I can call them that. And to answer that question, we do need to use the additional document that was provided to the court. It's a one-page spreadsheet, essentially. I don't know if the corporate branch could get that. I should say this was prepared by Teneo overnight. Its purpose is simply to draw out what the figures mean, rather than to introduce substantive new evidence. In effect, it unpicks some of the hidden rows within a spreadsheet that was used to produce the previous table. Now, from this document, we can see exactly what those three buckets consist of. So just looking at the very first row, my lords will see a reference to the participating secured creditors re-owed money. This is just the debt conversion into equity. And you'll see that there is a figure of 125 million. That is the first part, the 695 figure. That's the value of the equity allocated for the owed money. Then, if you go further down the spreadsheet, you'll see a row entitled fees. And that is then broken down into two parts. The fees payable to the participating secured creditors, that's the backstop fee and the work fee, and the fees payable to the new financial investor, that's Nuttree. We'll ignore that for the moment, but I will come back to it shortly. The figure that I'd like to focus on for now is the figure of 69 million. So that figure represents the fees bucket of the three-part blended calculation leading to the 695. And then the third bucket, and the largest one, is the net return on the new money. And my lords can see that immediately under the row, in bold text, new money providers. So that below that you'll see participating secured lenders, and the likely low case return is 500 odd million. And that's on 187.5 million of new money advanced.
Which is half equity, half debt.
That's correct. That's precisely right. So I just thought it might assist the court to show the court how that blended calculation actually works. Now, that answers the
So
first
just to be
part.
clear then, the 500 million is net of all that's been input into it. So another way, I'm not saying one is better than the other, but another way of presenting this would be to split out the debt element, because in return for the debt, you get, well, in return for injecting cash, you get a debt of the same amount. So they balance out. So if one's looking to see what is the equity return, it's not right to say it's 500 million in return for 187,500. It's 500 million in return for 93, whatever it is, half of it, which is the pure equity injection.
Yes, I think I agree with the substance of that comment up until perhaps the very end.
There is some equity in relation to the debt as well, I think.
Yeah, that's precisely right. So in relation to the new notes,
Yes.
two things happen. Firstly, you have a claim for repayment, principal sum advance. But there's more going on than that. Firstly, there's an equity entitlement, but secondly, there's an element of reinstated debt as well. This is the so-called reinstated notes of 60 odd million on an injection of 93.75. Now that's different from simply receiving back money that has been advanced. It's what people sometimes, it's similar to an OID, an original issue discount. So that has been factored into this figure, and that's the only reason why I balked towards the end of what the Lord said. But in principle, it is correct that the returns on the equity outweigh the returns on the debt, as one would expect, for reasons Mr. Allison will come on to, because the equity is vastly risky.
So the percentage figure that is then given of 266 is in fact a blended figure. And in fact, if it was expressed as a return on by reference to the injection of equity, it would be higher.
Yes, Lord. Yes. One point worth noting also is that the new money comes as a kind of package deal, so it's not possible to elect only to participate in one part and not the other. And so, to that extent, there is a logic underpinning the blend in this case, because for every dollar of new equity provided out of the 187.5, an equivalent contribution of new notes must be made. So it's a package deal. Now that deals with the first part of the Lord Justice Zacaroli's question. But the second part of the question was this: how is it that Teneo's figures bridge to the total value available for distribution in the restructuring? And we can see this from the table as well. Now, the way to look at this in the most straightforward way is as follows.
And sorry, just before you do, and I don't want to cut across, but the 211 figure at note 7, the blended average return, that's the figure that the judge picked up in his paragraph 89.A1, I think.
So Lord Justice Snowden has the point that I was going to make. The overall blended return for the new money providers is essentially 212 to 271. The judge recorded it as 272. That figure can be found in the judgment at paragraph 44. It's a table that appears at 4 bundle tab 7 page 215.
Yes, but I was referring to where he picked it up at.
81 Roman 1. Yeah, 89 Roman 1. Yes. Yeah, precisely. But it's ultimately derived from this table. And just to explain where this table is derived from, this table, which contains the new investor return of 211 to 272, is derived from the appellant's expert evidence in the court below. That's the report of Mr. Johnston. Just to put this on the transcript, the reference to that is supplemental bundle tab 15, page 539. We don't need to turn it up. That won't be controversial. And so that's the derivation of that blended percentage range. But as my Lord Justice Snowden has pointed out, it is a blend. That's entirely right. And it's actually a blend. That is a blend of a number of things. It's a blend of the returns on all of the new money provided. It's also worth just bearing that in mind in order to understand the calculation. But we do say that the judge was right, certainly mathematically, in his use of those figures. Unless there's anything further on that point, I was going to turn to the question of bridging from the figures that one sees in Teneo's table to the total value available for distribution in the restructuring. Before I do that, I'll say this. I think a comment made quite understandably, with my respect to suspicion, by Lord Justice Zacaroli was that there's a lot of figures that are used. One has equity value, one has enterprise value, and they mean slightly different things. What this table seeks to do is to identify the value available for distribution to creditors and shareholders in the restructuring as a whole. And essentially that works in the following way. Firstly, one can see from the first table entitled Plan Creditors that the likely low returns to them amount to $329 million. You can see that that's the bold figure at the end of the likely low return to the plan creditors. But one then has the returns to the other stakeholders, including the plan creditors in their capacity as new money providers and in their capacity as recipients of fees. We think it's helpful to separately itemize those. And those are set out immediately below. So we have the reinstatement of HSBC's claim. HSBC receives a new debt claim for $49 million. We have the equity allocation to the non-participating shareholders, which was required in order to pass the resolution required to make the entire restructuring work. That's 18 million. We have the fees, to which I have alluded, including the fee payable to the new financial investor. And then we have the returns on the new money. And if one adds up all of those sources of value, as it were, the total quantum of value available for distribution to everyone is 1.432 billion.
That includes, as you said, a debt element as well.
It includes the returns on the debt.
Oh, well, but HSBC, I thought you said they were getting money rather than shares. Is that not right? What's the HSBC figure of 49 million?
They're getting reinstated debt. So I suppose the point might be made that since they're simply having a debt claim reinstated, that's not an entirely conspicuous presentation of the position, because...
But everything else is a distribution of the equity, isn't it? And that bit isn't. But that's the only bit that isn't.
Well, coupled with the reinstated notes in respect of the new notes, my lord, it's the same point as before. But subject to that qualification, I think that is broadly correct. I think that is broadly correct. Now, I mean, we don't actually have a pie chart here, but one could create a fairly simple pie chart to visually depict the allocation of the value available in the restructuring. Put simply, the value available in the restructuring will be allocated as to about 66%, almost exactly 2/3, to the new money providers. My lords, there are two reconciliations just showing how that figure, the value available in the restructuring, reconciles to the equity value and the enterprise value. I don't need to trouble the court with that, but basically the point is that there are some technical elements of the definitions of these terms. For example, enterprise value deducts cash or disregards cash, and therefore doesn't in itself give a full picture of the benefits of the total value available for distribution in the restructuring. Likewise, the equity value doesn't really do the job because it disregards any additional debt that is allocated. So that's why we've sought to present the matter in this way. I should say these figures haven't yet been agreed with the appellants. That's largely a matter of timing, I suspect. It is essentially a spreadsheet, but we suspect that at the end of the day, to the extent that there are any disagreements, it's going to be very much a point of detail, I suspect. I think that the figures shown here are highly likely to be sufficient to make whatever point the appellants wish to make. So unless I can assist any further on this table, that was all I proposed to say, just to try to assist in explaining how the 10A figures work.
Yeah, that's very helpful, thank you. Right, well that's probably a convenient moment just to break for, well, I'll say 5 minutes, but it'll probably be a few minutes more than that, but certainly if people can try and get back here just after midday, that would be ideal.
Do you know what? It will crash, and I wonder if it. No, I know. No, that's. I live like 2 That is stress. Oh my God. This is going to take a restart. Start a new file. You can do about it.
Yes, to sleep early, right? What's that one? Wait, can you just give my AirPods, please? Yeah. Thank you so much.
I always keep asking you for that. I keep ticking this box.
Yeah,
That's why I couldn't get back into that. I knew it would do this. Yeah.
No. Go for it again. It's easier. Just give me the key. What's that tell me? Yeah, no, what's that? Just what's that? My lords, thank you. As my lords know, the judge found the new money was required, that it was competitively priced, and that it involved considerable risk.
What does he mean competitively priced?
It means, and just to show my lord what he says in that regard.
Well, that's what he says. Well, sorry, actually what he said is, I'm satisfied this return is a competitive one. What do you mean the return is competitive? Meaning what?
Maybe, can I just double check? Because if we want to look at what the judge says, the best place to start might be Core Tab 7, page 221.
Okay, but just to be clear, that's the reference you were picking up, was it?
Well, yes, I'm taking it in stages now, I think, just so one can see it in the judgment. So 56, looking at the new money, and in number 56.1, he says it's a high-risk restructuring and the rewards for providers of the new money are considerable, but I consider this to be reflective of risk not a gouging of a company that is going bust. And we say the conclusion, having heard all the evidence in there, that it is reflective of risk is key. There is no suggestion that it is bounty, disproportionate, any other formula one wishes to insert. It is reflective of risk. And to be clear, that's dealt with very carefully in Mr. Sousa's evidence. And the challenge I think set by Lord Justice Snowden is what are the risks? I'll go through it. I mean, our primary position is it's a finding of fact made by the judge having heard.
But it's not a finding of fact, it's an evaluation.
Which falls, then put that way, which falls, we would say, well within the bounds of the evaluation he can make in the exercise of his discretion, having heard all the evidence.
It's not a discretionary decision either. It's an evaluation of the evidence.
Well, which, again, we would suggest, number one, it is actually a finding that the new money is reflective of risk. He's found that on the evidence. And that number two, even if it is an evaluation, it is again well within the boundaries of a conclusion that could be reached by the first instance judge and indeed amply supported by the evidence. It's not suggested there was no evidence.
No, well,
finding.
let's look at the evidence.
Well, my Lord, I'm of course more than happy to do that, although...
You see, I mean, at the moment, I'm not sure exactly what that finding means, expressed in that very general way.
Well,
So, I mean, speaking for myself, I'd quite like to actually see the evidence which you say that was based on.
well, of course we can do that. So that may take some time. We do have one page of references that I can give to the court that captures all of the evidence given in relation to the need for the new money and the risk of the new money and the pricing. If I hand them up, we'll send them electronically as well. What we do within this document, and to be fair, it's not suggested by the appellant. There was no evidence for the judge to reach this conclusion. But what we do in this document is identify the key passages both within the evidence before the judge, Mr. Sousa and Mr. Reid, who then attended for cross-examination on the terms of the new money, the negotiation of the new money, the fees that were payable, why the difficulties in getting the new money, including the very broad outreach to the market, and the fact that the returns have been subject to a hard commercial negotiation and represent the best terms available. I would respectfully suggest that the evidence within Mr. Sousa's witness statements is considerably more detailed than I certainly have seen on the plans. He deals with these points very carefully.
Okay, well,
Do
do you want to take us to the highlights?
Well, can I just maybe go back to the judgment?
I mean, the challenge is that this is not, as far as the new money coming in post-restructuring is concerned, that this is not risky. That is the challenge.
Shall I meet that first then, and then I'll...
Well, it has to be met on the evidence, I think.
Well, no, of course, which I'll maybe focus on that question first, because I clearly, if my Lord's focusing on risk, I'll deal with that. The evidence very carefully deals not only with risk, but how many people were approached, how hard it was to fill the gap.
You see, I mean, okay, just to be clear, 56.1 of the judgment you took it to, this is a high risk restructuring. And what does he mean by that? Does he mean there's a risk the restructuring won't happen? That's what it seems to be. And then secondly, he says the rewards to the providers of the new money are considerable. Okay, I think that's clear. He says, but I consider this to be reflective of risk. But what risk is that? That's not the same as the risk of the restructuring. This is the question of the risk of providing new money to a restructured company, which is worth between 1.5 and 1.85 billion, conducting an ongoing business.
I think he is dealing with
So the question I've got is there a disconnect in the judge's assessment there, of, depending on what he's actually talking about, which he, and I'll be clear, is this something which he then comes back to in paragraph 89, 1A, where he talks about the contributors of new money. And he says at 89.1, if you look in the under the heading contributors of new money only, that they choose, now but this is good for all new money. They choose to involve themselves by injecting 226 of new money, but only if the plan is sanctioned. Now that's true for all the new money. It only goes in if the plan's sanctioned, right? And then in 1A, he says, this is a significant cash injection into an organisation that would otherwise fail. But that's irrelevant. The whole point is it's going into an organisation which it only goes into on the assumption that the restructuring succeeds. So that's just wrong.
Well, reading within,
isn't it?
Subparagraph 1, there he says, what he says is, I've accepted the plan sits at the very cusp of providing an acceptable return to these investors. That's his conclusion on the money.
Yeah, but sorry. You started us off at paragraph 56. Don't want to get distracted. You started us off at paragraph 56 with saying that we can't question or interfere, in essence, with the finding at paragraph 56, little 1. And I'm trying to unpick what that actually means. He first deals with this is a high-risk restructuring. Now, I accept that the restructuring has taken a long time to get to, and there's a considerable doubt about whether the restructuring will succeed or not.
My suggestion there, by reference to the evidence, as I will in a moment, is he's talking about the high risk, as explained to him, of an equity investment in a topco in a contract-only business going forwards.
Okay, because that's if that's what he is talking about, then in a sense you're coming closer to then dealing with the point that I want, certainly speaking for myself, I would like you to deal with, which is that given that the new money only goes in once the company is restructured and has a value of between 1.5 and 1.8, that's not really a very risky investment. Now that's the point that is made against you by Mr. Thornton and Mr. Coldclough in their skeleton argument very clearly, and that's the one you've got to deal with.
Well, let me now take that head on, because we do say the finding of the judge is in that context by reference to the evidence, and maybe in view of time to give my lord some highlights from the evidence.
But this is important stuff, so don't feel under pressure to brush over it. Because this is really, we're getting to some quite the centre of the beast.
The document picks up the references, but can I take the court to a few examples?
Yeah.
Can I take the court first to the explanatory statement, SB 411394.
So I missed that page reference.
I'm so sorry, 1394.
Sorry, it was my fault. So I was talking.
Can you give me the page number in the document itself?
Oh, of course I can. It should be tab 41.
Yeah.
And it should be page 214 within the document.
Thank you.
And this is dealing with the jurisdictions in which the group operates. Starting at 3.9. So the point made within this section of the explanatory statement is that the jurisdictions in which the group operates are high-risk jurisdictions which have been impacted by geopolitical events. So that there's underlying uncertainty in relation to the returns that need to be generated for the business plan to succeed. And the court will see the punchline at 3.13, the impact that can have on the group's performance. So that's the first point where the operations are located. The second point, and we can take this from Mr. Sousa's evidence, supplemental bundle, tab 6, page 184. Paragraph 2.1. And this really chimes with the point I made earlier this morning. This isn't the case in which there are hard assets, whether by way of property, IP or otherwise, but for the group to succeed, it needs to succeed on the underlying contracts. And Mr. Sousa makes this point at paragraph 2.1, and he says, in short, the group is a contracts business. It relies on those contracts and the relationships with its clients in core geographies to succeed and survive. And then he gives the example, because of the Thai oil, what can go wrong if one of the underlying contracts goes wrong.
Sorry, I must have got the page wrong. I'm looking at a paragraph 2.1, but I don't think it's the one you're looking at. Can you give me the page?
184, my lord, I'm so
That
sorry.
is the one I'm at then.
Paragraph
Okay.
2.1,
Yep, that's where I was looking.
the second sentence, in short, the group is a contracts business.
Oh, I'm sorry. Yeah, okay, sorry. Right. Oh. The Clean Fuels project is an outlier, meaning all the other contracts are better than the Clean Fuels project. Is that right?
Maybe that's a disaster, and that's common ground, but it's not an outlier in the sense that contracts can go wrong, which
Sure.
is dealt with by Mr. Sousa in his evidence. And maybe just does my lord recall from the evidence the reference to Tenet, which is the key counterparty to a number of the group's contracts? Essentially, the termination of one contractual relationship can lead to existential problems for the group. Next point is in relation to where the new money goes in. It goes in an equity, which of course is structurally subordinated at the top of the group, subordinated to every liability of the top company, and importantly, subordinated to every other liability of the contracting subsidiaries. So while the scheme will deleverage the group, problems under customer contracts still give rise to considerable unpredictability and risk. And Mr. Sousa himself makes, and that point's made actually in the explanatory statement as well, to give the court a reference to that. It's supplemental bundle 41, page 1386. Does the court see at page 1386, page 206, internal numbers, paragraph 2.32 in particular, where Mr. Sousa begins his explanation that the group is exposed to concentration risks from its dependence on a small number of large contracts and a limited number of significant clients at any given time.
Sorry, 1386.
1386 explanatory statement.
So it's not Mr. Sousa. This is the explanatory statement.
My lord, I misspoke. I'll come to Mr. Sousa in a moment, if I may.
Yeah, I mean this is just this is part of a this is part of a risk. It's part of a section, presumably risk factors or something, isn't it?
My lord, it is absolutely
Yeah.
explaining all the risks around the new money.
You mentioned the deep subordination of the new money. That's not true of the debt part, is it? What security package does the new debt have ability of, or benefit of, if any?
My lord, there is security, but I think the key, and I'll check behind, is over what, in the sense that the relationships are with the contractors at the subsidiaries, and I don't believe there's any additional security there, but I will check.
that, because the previous package was a cross-group security package, wasn't it?
No, it wasn't. For example, that's why in the PIUL plan,
Right.
everyone is unsecured.
But perhaps you check to see how well the security.
Of course. I mean, there are a number of other references within the explanatory statement that I could show to the court, but to the extent that the courts would like to look in relation to the difficulties in finding the new money.
So have you stopped? Is that all you're going to show us in relation to the risks going forward?
My lord, no, let me keep going then. They are predominantly within the explanatory statement.
Well, which isn't evidence, but I thought you were going to take us Mr. Sousa's evidence.
maybe I can now go to Neo's report to show the assumptions within that. I'll hopefully come back to a couple of references in Mr. Sousa in a moment.
Okay.
And that is supplemental bundle tab 14, page 514.
Tab 14,
Supplemental bundle tab 14,
voting update.
which was provided to creditors with the risk factors.
Okay.
And before the court, in the sense that this was confirmed by the expert, Mr. Bennett, who attended to give evidence, as also being part of his evidence to the court. And one sees within the summary of key valuation assumptions, beginning at the bottom of the first column, one has an expectation of 3-year growth of 48.7%. One needs to generate more than 80% of its revenue from unsecured contracts by 2027, but a third of that is committed. That there are other issues in relation to continuing operating losses. Issues in relation to restriction of cash that won't be available to the group for an extended period of time because they're ring-fenced by customers. So significant risks attached to achieving the enterprise value.
And taking all that into account, he then settles on a multiplier and comes up with a value of between 1.4 and 1.75 billion. I mean, he's taken into account all those risks that you are identifying, and still the valuation is 1.4 to 1.75 billion. It's not that he's not factored in all the risks post restructuring. He has factored in all those risks. In fact, if you go to the actual valuation report, there's a very similar and lengthy section of risks that are factored in of the types you've been talking about, which are classically then factored into the selection of the multiplier, which he does, and he comes out with a value of 1.4 to 1.75. If this was a very risky business, he wouldn't be using multipliers like that.
Well, I think what we, and again, we can say on that, like, at the risk of pushing at a point I made earlier, in relation to the risk of the money, in particular the points in relation to where the business units are located, that the equity will be subordinated to all claims within the group.
But he takes all that into account. I mean, that's what a valuer does. He takes all those points into account. He takes into account the structural subordination of the equity. He takes into account the risk factors of the business. He takes into account all the things that you're talking about, which he's identified. And if you look at the actual valuation report, which this is an update to, there's a very lengthy section dealing with all these points. And then he chooses an appropriate valuation and comes out at 1.4 to 1.75 billion. I mean, how is that consistent with saying that post-restructuring, this is all very risky?
That is on the assumption that the business plan of the group will
he factors that risk in as one of his valuation factors into the selection of the PE ratio to the multiplier, doesn't he?
I don't.
Well, if he hasn't, very surprised if that's what he hasn't done.
The report is prepared on the assumption that the business plan will be achieved.
No, I don't think it is. I don't think it is on an assumption it will be. He factors in the uncertainty that it might not be. I mean, if you look at page 1489 of the supplemental bundle, which is the start of his assessment of key issues and trading uncertainties in relation to the business plan, which leads him to produce a valuation. I mean, he highlights the uncertainty in obtaining performance guarantees. He highlights the potential risks involved in revenue, gross margins and cash flows for the business. He highlights the unsecured E&C, whatever that is, and contracts customer. He highlights the commercial risks in relation to project execution. He highlights the potential upside downside accounts of certain contracts and ongoing legal things. These are all the factors that any valuer will take into account when producing a valuation. And he still comes up with a value of between 1.4 and 1.75 billion. Why is this valuation not, you know, why doesn't it do what any normal valuation does?
Well, we'll look at the key assumptions, but I believe he is. I mean, I think I was right to say he is assuming.
Well, it's page 91 of the valuation report, internal page, I've got it separately. I may be misreading this, but under the heading summary of key valuation assumptions, it deals with the points you make about high revenue growth, etc. Then under the bullet point WACC, our concluded WACC range of 21 to 24% reflects the execution risk in the business plan, that it's predicated on the group's ability to secure guarantee lines. It captures the potential risks of operating as a high growth business with a significant proportion of unsecured contracts over the forecast period. It further captures the customer concentration risk within AD/NOC and tenant representing 70% of total E&C revenue, i.e. the points you've just taken us to, I think.
Yeah. I mean, frankly, if it were otherwise, and this was simply put forward on the blind assumption that everything that management had projected in the business plan would be succeeded, there'd be something else to be said about the way that this has been put to creditors.
Well, can I maybe just show the court page 1493 to show the way that we had understood the report is put together when dealing with limitations and key assumptions. So internal page 28.
Is this part of the valuation report?
My lord, yes, this is. So within the supplemental bundle, it's tab 48, page 1493. Loose copy, it's page 28. So they introduce the sources of information and then the limiting conditions. In our analysis, we assume that management's forecasts are reasonable and achievable, subject to the successful implementation of the proposed transaction, namely the restructuring. They then assume that there will be continued ability to deliver existing contracts and win new ones. They note that a difficulty in securing performance guarantees could negatively affect the group's ability to win and execute the business plan. We rely on the business plan provided to us, which we understand from management is representative of the most likely scenario of the group's future financial performance post-restructuring and securing performance guarantees. So in other words, what they are working on and assuming is a post-restructuring business with the capital structure post-restructuring, which can continue to obtain performance guarantees. They also rely on management anticipating that the group will be sufficiently recapitalised post the proposed transaction, assuming that the new money is invested and will fully fund free cash flow losses estimated in 2025. And then the last bullet point was the source of the point I made earlier. Petrofac deliver forecasts to plan, specifically with respect to revenue growth for E&C, including ETP, expected profitability and cash flow generation. Additionally, we do not consider the potential upside from any additional future contracts not reflected in the business plan. So, our understanding of the report in clear terms, and I think made further emphatic in the penultimate bullet point in the page, where they say our valuation analysis is prepared on a going concern basis at the valuation date, and therefore it doesn't reflect the potential future or potential exit value of the group. And then we also note that if the group tracks its financial forecast in the business plan, its cash flows will be further de-risked. So the value could get higher if everything goes well, but at the moment, they are assuming.
Do you want to turn the page? Do you want to read out the penultimate dot on page 1494?
Well, the further assumptions in appendix 1, yes.
As demonstrated in the report, we've held extensive discussions with management and its advisors in preparing our valuation analysis, including but not limited to the group's historical operation and financial performances, competition and market outlook, sales expectations and customer pipeline, operating margins, working capital assumptions and other cash flow forecasts. Throughout these discussions and our review of the business plan, we have identified and documented the key risks associated with the forecasts, which are then reflected in our assessment of the discount rate estimates and sensitivity analysis of part of the income approach DCF analysis, and in our selection of the multiple range as part of the market approach corroboration. He's done what valuers do, and in taking the discount rates, the WACC, and the sensitivity analysis and the multipliers, he's taken into account the key risks associated with the business plan. That's what that means, isn't it?
Well, my lord, is in his role as a value, yes, but I think in terms of risks, my lord's question was risks.
Yeah, but he's taken into account all the risks of the business plan going forward, and he's factored that into that DCF analysis into his valuation. So having factored it in, he still comes out with a value for this company post-restructuring of 1.4 to 1.7 or 1.5 to 1.85.
My lord, it does, and we're not dissenting from that for a moment, because of course that is the valuation evidence we put forward. I think that.
How is this a high-risk company on that metric post-restructuring?
The risk of repeating Mr. Sousa's evidence deals with it in the context of all the efforts to find new money. It's regarded as a high-risk investment by investors because to generate the equity value, one needs to have performance in accordance with the management's business plan. One needs to have a situation in which contracts do not go wrong to make your equity returns, to deliver the value of the business. And in those circumstances, by assessing their risk appetite as to where to put their money or not put their money, this is seen by investors, that being the key, as a risky investment, as explained by Mr. Sousa in the context of the extensive outreach made to investors and no good results, and as explained by Mr. Reid as one of the ad hoc group in saying, this is high risk. I think what with respect one can't do is equate an independent expert's opinion of the likely valuation of the equity if the plan succeeds with that naturally translating to the risk that would be seen by an investor when deciding whether to part with its capital as part of the transaction.
Where does the judge deal with this valuation and this assessment of the fact that it deals with the assessment of risk going forward.
Well, we'll check. I don't believe he does. I think what he deals with is the evidence that he's had from, in particular, Mr. Reed in the box and
This valuation report was in front of him.
My lord, it was in front of him. There was no cross-examination on it. Mr. Drummond wasn't called.
I'm just taking it as face value. You don't need to cross-examine anybody on it. It says what it says. It says that we factored all the risks that we've determined in our discussions with management in whether the business plan will succeed or not, and we factored that into our choice of the parameters for the DCF valuation, and it's come out at what it's come out at.
That clearly that's his evidence on what the number is. Again, at the risk of repeating, that in our submission is not the same question as do investors regard this as a risky use of their capital when it comes to finding the relevant pricing of new money and who will participate.
Was there any expert evidence addressed to that question? What would an investor be prepared to pay to invest in this business?
The evidence...
Expert evidence. Was there any expert evidence?
No, there wasn't expert evidence. There was evidence from Mr. Caesar, as referenced in the one-page document, about the enormous amount of potential investors he had approached.
Yep.
The fact that, having gone through many funding rounds and had no success, they managed to obtain a small part from the existing creditors, then adding to that book over time to get up to the money need during hard-fought negotiations to agree.
That's all part and parcel of the restructuring as a whole. My Lord's question, I think, unless I've misunderstood it, is directed at the new money piece, i.e. what would somebody asked in the market to lend to the restructured company have demanded for lending new money?
Well, in that regard, Mr. Sousa deals with that in the sense that he says that they went back out.
Well, can you take us to it? Because
Of course, it's Mr. Sousa 4. So within the supplemental bundle, tab 6. If one goes to tab page 214, does the court see the heading IBR at the top of the page? This is a description at 6.7 through to 6.10 of further steps made by the company to seek other investors once there was an IBR dealing with the business plan on the assumption that the restructuring would have the effect that
IBR is what? Sorry.
Independent business review.
So this is deciding how much money the group needs.
Yes, exactly, in relation to the business plan, it helps size that.
Okay. And it's not suitable for investment purposes. In other words, it's not part of a process that actually involves asking people to invest money.
Well, my lord, I think the key point in relation to that is, although an IPR is not designed for that purpose, what was done with that IBR is it was made available so people could see the impact of the restructuring when seeking to build the book in relation to the new money. That's 6.9.
And the people who engaged via the Lazard process, they were people who'd been asked to get involved in the restructuring as a whole. That's what the Lazard slides show, I think.
Yes, they are not. It's not just plan creditors, it's a wide outreach.
What were they being asked to consider? So were those presented with the IBR within this process, which was taking place in October, November 2024, I think? What were they being asked to consider doing?
To ask to consider whether they wish to invest into the company. This was done by Mr. Sousa during the equity raise.
Invest in the company in what state?
With the restructuring, on the assumption of the restructuring, which by that stage had been announced.
Where do we see that? Because what I've struggled to find is that clear evidence of that fact, that what people were being asked to invest in was essentially the new money into a restructuring group.
Can we maybe go back then to Mr. Sousa's first statement where he deals with the introduction of the IPR? So if we go behind tab 1, and if we go to page 66, (10.7), the Alex Partners report, that's the IBR. And they identified, consistent with the group's business plan, that with the benefit of the restructuring, there was scope to deliver the turnaround of the group and material liquidity in financial year 26 and beyond.
So, but that's 10.6. In order to form their investment decision and willingness to provide backstop support, and in order to assist to identify other potential investors, the ad hoc group requested the group to obtain an independent business review. So it was done primarily for the ad hoc group in relation to their investment decision and willingness to provide backstop support, and in order to identify other potential investors, but what in?
In the new money need,
Well,
which was identified by
sorry, but
the IBR report.
But it doesn't say that.
It says to identify other potential investors in the context immediately of having identified the new money which is being discussed under this heading at 10.5 and more generally.
But this
the
is
new equity investment.
This is just to decide, to assess the group's business plan, the levels of the new investment that would be required and could be sustained. Well, I mean, do we have that? I mean, that's a very bland description without some fairly, well, there's just no evidence of what that report is and who it was shown to. Or, as my lord has already asked for, what's the context? What were they being asked to do? The people unidentified to whom it was shown.
Well, that was dealt with at 6.9 of SUSA 4 that we looked at a moment ago, who it was shown to. The report, reminded, was in the convening bundle, although it is not in the bundle before this court. But as we saw in SUSA 4, what happened to that report, which assumed a restructuring and was prepared and given in relation to discussions in relation to new investment, was then provided more widely by Lazard within the Lazard process. That was 6.10 at page 214.
So do you want to look at the Lazard process, tab 2022?
Well, we can. This is in advance of the restructuring, Lazard being engaged to look at other options
Is there anything in this summary, which I'm not sure what the date of it is, but is there anything in this summary by Lazards of what they did that focuses, as my lord has put to you, on who was asked to put in new money, and if so, on what terms specifically? I mean, what does this identify anything specific? What do you want us to look at in relation to this Lazard process?
It shows the extensive efforts made by the group to find alternative routes, which included page 840 of the report, either one, a sale of all or part, or two, an equity raise.
So it's not dealing with testing the market for new money.
Well, it is dealing with, not at this stage, it's dealing with a sale or an equity raise. And then within that context, at page 842, 57 parties were contacted with the results set out during within that page. The key bit in relation to the Lazard process, as explained in Mr. Sousa's evidence, is that following the IBR and the assumption of a restructuring it being implemented, they went back to a number of parties contacted by Lazard as part of a fundraising exercise. In other words, of getting in new money as part of the restructuring.
Where does it say that?
That was Mr. Sousa for page 214, paragraph 6.9.
So go back. So the last sentence of paragraph 6.9, it did not, so this exercise that you draw attention to, quotes, it did not prompt any further offers for the group. That suggests that's what he was asking for.
Our understanding of the evidence is it's not that limited. Particularly if one looks up, one can see within it the report was provided to 7 of the group's original lenders, 9 bondholders, including the AHG, and 30 investors, some, but not all, of which had invested. So it did lead to people investing rather than delivering offers for the group. I think 6.9 is merely conclusory in the sense that when looking at relevant alternative, there was no offer from the group. So I think he does show that it was provided to those within the Lazard process, and it did lead to some further new money investors coming forwards, but did not, hence we are in the world of needing a plan, prompt any further offers for the group. That's the way we read 6.9.
So is that it? 6.9 is the evidence as to what was done to approach potential investors to provide new money to the restructured group?
No, that is not the extent. I mean, I will collect the best references from the document to show to the court after lunch in relation to attempts. Clearly, there were. One can see there were extensive attempts in the sense that we have got new investors coming into the group, rather than this just being a case in which the current plan creditors are providing the new money.
Well, what you can say is it's an odd feature of this that with $909 million of existing creditors, security creditors, less than half took up this offer. So that's a point in your favour. But I don't know who the people who didn't take the offer were and why they didn't take the offer up. We don't have any information about that.
My Lord, what we have in relation to that is that they did not wish to take up the backstop. They didn't participate. And Mr. Reed's evidence, which I'll leave to Mr. Bayfield from an investor's perspective, is the risks involved. Because clearly from the company's side of the fence, we are trying to seek investment on the best terms. From the investor's side of the fence, they are looking at, do they deploy their capital in this way versus other.
But there's no evidence. We don't know who these people are, and there's no evidence. There was no evidence from them. I mean, my Lord's point to you is: look, it's a point in your favour. If these, and it's a point you make in your skeleton, if these terms were so disproportionately advantageous, why haven't more people in the group that was offered them taken them up? The answer that comes back is we don't know, because we don't know who the people who didn't take it up were, and we don't know why they didn't take it up. There's just no evidence. And my Lord was putting to you, do we know anything about these people?
Well, we know that they were institutions who held secured debt in the group.
Yes.
Clearly, and we know that they determined for commercial reasons that they didn't want to participate.
Where's the evidence of that? Where do they say that?
We don't have direct evidence from them in the normal way. That is just our assumption on the basis they didn't invest.
So, all right. So they didn't invest, but we don't have any evidence as to why that was. I mean, it might have been because they couldn't. It might have been because they just bone idle. Might have been that they didn't want to be involved further with this group. We just don't know.
Well, the court doesn't. We respectfully suggest that's wholly unsurprising. I mean, the idea of the company having to, as part of the evidential burden, adduce evidence from people who didn't invest for the reasons why
No,
they chose not to do so.
It's your point. It's your point. You make the point in your favour, but I'm just testing it because against you is said, okay, if that's such a good point, it said it's not a good point because we actually don't know why they didn't invest. You can't just draw the conclusion that you want us to draw, that these aren't really advantageous terms, that they are really risky, and that was the reason people didn't invest. We just don't know.
Maybe answering my Lord's question a different way, what I can say is that there were no complaints made in the course of the process as reflected in the evidence at the sanction hearing and at the convening hearing that members of the class entitled to participate were saying that it was somehow unfair because they were unable to do so. So there's no suggestion of inability being a problem in this case, as it is in some. It's just a fact that people haven't participated, and I think that we say is consistent with the very extensive efforts that needed to be made to raise the money in the first place, including outside of the creditors themselves. Well, I know the time.
Yes, right. Well, that's probably a convenient moment. So 2 o'clock.
Yeah, you too.
I need these. You got one, yeah.